Well, let's move on to a bit of pop culture. There's a movie. It was a 2020 movie. Someone turned me on to it a few months ago called "I Care a Lot," and I think I found it. You can watch it on Netflix. It's about conservatorship abuse, and I wanted to ask you a bit about it. I think you told me you haven't had a chance to see it, but you've read a little bit about it. For our audience who hasn't seen it, the premise of "I Care a Lot" is it's about a corrupt professional fiduciary, a conservator, who has a back scratching relationship with some doctors of wealthy elderly people, and the fiduciary will go into court with a declaration drafted up by one of her doctor cronies. And the declaration would state that, poor wealthy Miss Jones is desperately in need of the assistance of a professional conservator, and the judge would sign off on it and say, well, of course, Miss Conservator is a very well respected conservator in our court, and this doctor is a very, very well respected member of our medical community, and go ahead and appoint the conservatorship. And then the greedy corrupt conservator would go and loot the estate. And so I was watching this and thinking, now this could never happen in our system because and I thought, I'm going to ask David Greco that question. So David, why could the premise of "I Care a Lot" never happen in our system?
Well, the answer is that it does. Not, I think, to the extent that the movie sensationalizes it and dramatizes it. And I haven't seen any back-scratching relationships with physicians. And I really haven't seen any professional fiduciaries behave in this way. But I have seen conservatorship abuse. I have seen children attempt to have their parents conserved because they were written out of the estate plan and they want to get the conservatorship and change the estate plan. And I've seen children try to have their parents conserved because the parents stopped taking their phone calls because they don't want to talk to their child, which is, probably difficult for the child, but a conservatorship is not the answer. And, we have seen in our practice conservators take advantage of wealthy disabled people. We had a case, it must have been many years ago by now, where the stepdaughter of this very wealthy, taxable estate type gentleman took it upon herself to take him to a new estate planner, deed a bunch of his properties to her using the conservatorship. And then when her conservatorship status was contested, she locked him in the house with her. She refused to let the court investigator interview him. She refused to let any of the examiners see him. And it was a protracted, really contentious battle. There was a guardian ad litem appointed, and there's so many other children involved. And I want to say probably that case cost collectively the parties, 7 or 8 figures to litigate over the course of however many years. So it does happen. But the good news is that the legislature has started to catch on with the Free Britney movement. I think that somebody thought, this might be important. And so they did implement some new changes this year to the conservatorship laws. They broadened the types of people who can ask the court to investigate conservatorship abuse. They increased the penalties for conservatorship abuse against both individuals and private professional fiduciaries. They broadened the investigators' powers. And there's some other stuff in there that it's moving in the right direction. And of course, one of the most important things that came out of the Free Britney movement, so to speak, is that conservatees can now choose their own counsel. And the Business and Professions Code has been incorporated by reference into this new section to make clear that the conservatee's chosen counsel's job is to advocate for the conservatee's preferred position, not what the counsel may independently think is best for the conservatee.
Right.
And so, the changes are positive, but I don't think they're enough. And also, many of them are funding dependent. They're subject to a separate legislature bill providing funding for these laws to go into effect. And who knows when or if that'll happen.
Yeah. No, that's interesting. So you're saying that a moment ago, you said that one of the recent changes is that proposed conservatees or conservatees now have the right to retain their own counsel to advocate for their own positions. I'm surprised that I was not aware that that's only a recent development. How recent is that?
It was passed, I want to say at the end of 2021 and goes into effect this year. And,
So before that, you would have conservators or guardians ad litem who would just go into court and say, well, this is what I think Mrs. Jones needs. And no one would be hearing from Miss Jones as to what she actually wanted.
That's right. Yeah, court-appointed counsel. And it really depends on the court-appointed counsel, because some had always viewed their role as advocating for what the conservatee wanted. Other court-appointed counsel viewed their role more as a guardian ad litem, somebody to act for the conservatee. And so the change in the law really makes it clear that you act on behalf of the conservatee.